Well, thank you so much for joining everyone, and good afternoon. I'd just like to welcome you to this event discussing the new book, A Theory of African Constitutionalism. And today we're lucky enough to be joined by the author, Berihun Gebeye. And Berihun will first give a talk on the book for about 20 minutes, and then we'll have discussant remarks by myself and Massimo Fichera. So just to give a brief introduction to the author. So Berihun is a Humboldt Postdoctoral Research Fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. He teaches and researches comparative constitutional law, human rights, and international law and development in Africa using interdisciplinary approaches and materials. Previously, he was a postdoctoral research fellow at the University of Göttingen and a visiting scholar at the Columbia Law School, the Center for Socio-Legal Studies of the University of Oxford, and the Max Planck Institute for the Study of Religious and Ethnic Diversity, a global teaching fellow at the University of Yangon in Myanmar, and a visiting professor at the Central European University. And Berihun holds degrees in law, human rights, and comparative constitutional law, and has extensively published in these fields with a focus on Africa. So we're very lucky to have him with us today to discuss his new book. So he'll speak for about 20 minutes. And then, as I said, we'll have discussant remarks, and then hopefully we'll have a good 30 minutes or so for questions and comments from the audience. So thank you again, and I'll turn it over to Berihun for his remarks.
Thank you so much. Thank you for Kathryn for this generous introduction. I also would like to thank the Edinburgh Centre for Constitutional Law, especially Asanga and also Praver for organizing this book discussion. I also want to thank Kathryn and Massimo for joining us today to discuss my book. Thank you also for everyone for coming to this discussion. I know that this is the center's first event, but they have had many wonderful talks before, and I am sure many more are coming, but I'm really pleased to be here. So the theory of African constitutionalism is about many things. It is about political and constitutional transformations of the continent since the colonial encounter. It is about the nature and structure of public law in post-colonial societies. It is about how African societies and states interact and operate internally and internationally. It's about decolonization. It's about the promises and limits of the territorial state for full self-determination. But most importantly, it's about how we could better understand, improve, and assess constitutionalism in Africa on its own terms. The starting point for the book is the transformation of colonial status to independent status in the 1950s and 60s, but the transformation of African societies and status to colonial status in the late 19th century. The frame of reference is the Berlin Africa Conference of 1884 and 85, which acted as a basic law or constitutional law for the establishment of new territories, peoples, governments, and sovereignties over pre-colonial constitutional arrangements. The founding constitutional value and mission of colonial status, which post-colonial status inherited, were not establishing limited government, protecting rights, or institutionalizing the rule of law, but it was rather establishing an extractive government and state apparatus that was affront to rights and the rule of law, which didn't go away with the end of colonialism. The inherent contradictions of being born from a colony, the expectations of independence, and their unequal membership to the international community have coerced African states and societies to rethink the classic notions of constitutions and constitutionalism. But in this talk, I will only focus on 3 themes of the book. First, how others have looked at the notion of constitutions and constitutionalism in Africa. Second, the theory I advance in the book. And third, how the book may require us to think differently about constitutionalism in Africa. The major discussions on constitutionalism in Africa thus far revolve around 2 major frameworks: legal centralism and legal pluralism. Legal centralism is a state-centric understanding of law, that law should be the law of the state, uniform for all persons, and administered by a single set of state institutions. Legal pluralism, on the other hand, refers to the existence and application of customary, religious, and state laws within a state, with or without its recognition. And much of the constitutional scholarship and thinking in Africa follows either the legal centralist or legal pluralist perspectives. Legal centralists explain the idea and practice of constitutionalism through the prism of liberal constitutionalism, primarily focusing on the written constitutions. Their temporal starting point is the 1950s and 60s, where many African states got independence from colonial rule. Based on the legal centralists' account, that is limited government, protection of rights, and the rule of law, the performance of African constitutionalism has been a tragic failure or very disappointing. Legal pluralists, on the other hand, understand and explain constitutionalism on the continent from 2 vantage points. The first is through the lens of the state, and the second is through the lens of society. Inherent in this view is a bifurcation of the public sphere into the civil public that operates or claims to operate under the civil structures of the state created during colonialism, and the primordial public, which functions in accordance with indigenous custom since pre-colonial times. Legal pluralists hold that there are 2 publics operating under a different morality, rationality, and sense of justice. According to them, this creates a dual or parallel constitutional system, which makes the liberal constitutional project simply a chimera on the continent. I disagree with both approaches. I argue that the legal centralist and legal pluralist theoretical frameworks couldn't capture and explain the constitutional systems and experiences in Africa. This is simply because these approaches fail to account to the specific normative and empirical settings of the African state at the local, national, and international levels. The legal centralist approach fails to account for the specific empirical settings of the state, while also missing the role, position, and function of customary and religious laws and institutions in the operation of the state. The legal pluralist approach, on the other hand, also misinterprets the nature of the state, its organization, as well as its configuration with society and the international community. In the book, I argue that African constitutionalism is legally syncretic, that it is a unique blend of international law, colonial laws, indigenous laws, and liberal constitutional norms that both trigger and produce constitutional change and transformation, while simultaneously animate and structure constitutional design and practice in Africa since the colonial encounter. The syncretic origin and feature of African constitutionalism, I argue, is key for understanding, improving, and assessing constitutionalism on the continent. I will give you 3 examples how African constitutional design and practice is legally syncretic. The first is the state itself. The African state is a syncretic state in the sense that it was created and to some extent still maintained through a unique configuration of international law from above and indigenous laws from below. While international law gives the state, both colonial and post-colonial, internal autonomy and external protection through the doctrine of sovereignty, indigenous laws provide the state with the necessary infrastructure and resources for internal operation. These are the material conditions on which the written constitutions are working or supposed to work. Unlike the state in the West, which is relatively internally autonomous and externally immune from interference, precisely because it has an empirical rather than legal origin, a syncretic state particularly depends on and is vulnerable to both external factors, such as international law and institutions, and internal factors, such as indigenous laws and institutions. This syncretic feature of the African state changes the way we think about constitutional law and practice on the continent. The second example is the legislature. The legislature in many African states is a dual house of representation, based on the liberal notion of one popular sovereignty, one person, one vote, and the traditional form of sovereignty are symbolized in the lawmaking powers of traditional leaders or authorities. Traditional authorities are incorporated into the legislative branches of government in different ways, as part of parliament, as a separate house of chiefs, as part of local government, and finally, and most importantly, as authors of customary laws, which are one source of law in many countries. And the third and final example is related to constitutional rights. The constitutional rights regime in Africa configures both the liberal tradition and African cultures, such as the incorporation of constitutional duties along with constitutional rights, and different conceptions of equal treatment and equal concern, especially related to women's rights. Here I will give you one example related to polygamy in South Africa. In the case of Maylen versus Nguniama, the South African Constitutional Court decided that a subsequent marriage without the consent of the first wife is against the equality and human dignity envisioned in the Constitution. The court held that, I quote, where subsequent customary marriages are entered into without the knowledge or consent of the first wife, she is unable to consider or protect her own position. She cannot take an informed decision on her personal life, her sexual or reproductive health, or on the possibly adverse proprietary consequences of a subsequent marriage. Any notion of the first wife's equality with her husband would be completely undermined if he were able to introduce a new marriage partner to their domestic life without her consent. Given that marriage is a highly personal and private contract, it would be a blatant intrusion on the dignity of one partner to introduce a new member to that union without obtaining that partner's consent. End of quote. Surely the arguments made for the introduction of consent of the first wife can be deployed to challenge polygamy itself, or to extend to women so that they could also have more than one husband. Nonetheless, as the Constitution enshrines a syncretic theory of women's rights, the practice of polygamy continues to be tolerated, and courts try to find creative ways of enhancing women's rights within customary settings. In the process, both the liberal and the African conception of rights have been transformed into something new, to syncretic rights. So what does all this mean? This means that we must think differently about constitutional design and practice in Africa. Especially, we must take the issue of sovereignty seriously, constitutional reform comprehensively, and diverse constitutional values respectfully. I will say a few words about each of them. First, related to sovereignty. In the study and practice of constitutionalism in Africa, we cannot take sovereignty for granted. This is simply because post-colonial sovereignty is externally vulnerable and internally negotiable. Enhancing and consolidating sovereignty should be part of constitutional design and practice itself. This will require both thinking beyond the territorial state and thinking within and through the territorial state. Second, related to constitutional reforms. Since independence, the focus has been mainly on reforming or revising written constitutions without changing much of the legal system that provides the government and especially the public administration with their significant untamed political power. So without reforming the repressive parts of the legal system, constitutional reform may not effectively limit the power of the executive, and perhaps most importantly, the bureaucratic apparatus that is in close contact with the people in everyday life. Third, related to constitutional values. There is a dual commitment to liberal constitutionalism and cultural diversity across the continent. And the constitutional order is procedurally and normatively open to accommodate different constitutional values, which has created a relatively acceptable and livable constitutional environment for many diverse societies on the continent. So to conclude, the legal syncretic paradigm the book introduces not only offers us a new perspective of understanding the past and present of constitutionalism in Africa, but it also supplies us with some theoretical foundations and practical tools for its future diagnosis, improvement, and consolidation. Thanks so much. Thanks so much again, and I'm looking forward to discussing this further.
Thank you so much for that wonderful talk and for an overview of the book that I'm sure many of us will want to go on and read and get more information. So with that, I'll turn it over to Dr. Massimo Fichera, who is an adjunct professor at the Faculty of Law at the University of Helsinki, and he'll spend about 10 minutes on his discussant remarks, and then I'll offer a few, and then we'll open it up for questions.
Yes, thank you, Kathryn, for chairing this meeting, and thanks also the Edinburgh Centre of Constitutional Law for inviting me, in particular Asanga and Prava. So I haven't been able to, of course, read the book in its entirety, but so my comments are based really on this discussion, this presentation by Berihun, and on some pages that I've been able to read. And I have to say that I find this project really interesting. I'm keen on reading the whole book, and I think there's lots of food for thought. And what I'm really interested in is what we can make of this category of African constitutionalism, which you adopt. So I think that one aspect that needs to be emphasized is this dimension of legal syncretism, which you mentioned. You claim that there is some kind of you tend to adopt a meta level of analysis, as I understand it. So you place your analysis at a level that transcends both legal centralism and legal pluralism. So what I'm very interested in understanding more the distance that you take exactly from the legal pluralist paradigm in your analysis, because in my view, legal pluralism does not necessarily take a perspective that excludes or rules out the dimension of sovereignty within or through the territorial state, as you say in your presentation, So there is also, of course, sovereignty beyond the state. There's also the idea of sovereignty within and through. And as legal pluralism does not necessarily circumscribe or ignore that dimension, I'm interested in knowing how you really place yourself in respect of this. But I also find very interesting the possibilities that your analysis has precisely in looking at the local dimension decision making. And what I would like is to know more about the role of non-state actors in your work. All sorts of non-state actors, for example, NGOs, but also private actors. What is their role in this shaping of constitutions, African constitutions? And you also emphasize the element of the transformative dimension. Now, again, I haven't read the book, but what I would be interested in particular is you talk about the legislative, but what is the role of the judiciary in this transformative dimension? Well, one clear example would be, of course, Constitutional Court of South Africa. But would you be able to mention a pattern in different parts of Africa? And in looking at this new category, you can call it African constitution, you of course say, are very careful in saying that it is not a unitary category, it doesn't purport to somehow essentialized all the features of African constitution in itself. But isn't there a danger that in constructing this category, we are doing nothing but actually realizing a product of Western colonization itself? So in constructing this category itself, look at it through the eyes of Western colonization. And what is also the role of religion in your dimension, in your shaping of African constitution? And you then talk about, you of course talk about the promises and limits of the territorial state. But in your so is your objective that of somehow going beyond the territorial state? Because again, you say that you want to, as I said already, place yourself above, like at a meta level. But is your point that we should forget about the territorial state? We should look at it as simply an accident to history, or is your point rather that we should still start from it, we should still depart from it as a perspective, and then create some kind of integrating framework between the territorial state and international law? I think that would be also interesting to flesh out. And finally, just one last observation. You talk about liberal democracy. Now, one of the main features of liberal democracy, at least the way it has developed in Western world, is that it has built up a certain way of constructed interaction between rule of law and democracy. So on one side, rule of law, and on the other side, democracy, and it has decided that they should be interacting in a certain particular way. Does African constitutionalism indicate a different pattern of interaction between them, or does it follow in the same path? Thank you.
Thank you so much. So lots of questions to start off. I'll add a few to them, and then Berihun, perhaps let you respond while we let the folks who have joined us think of some questions to start off the discussion. So as Asanga mentioned when we were chatting before the event, I have recently done some work on kind of regionalism in Africa, and my field looks at kind of the intersection of international law and international relations. And it struck me the similarities between kind of regional governance as well as constitutional governance within states. And the things that I really appreciated about the sections of your book that I was able to read, as well as your presentation, was the call to address African constitutionalism on its own terms and to understand it within the African context, as opposed to applying kind of external filters to our understanding. And in my work at the regional level, have also found it very important to look at the development of norms and structures and governance over time. And that often we focus kind of far too much around the immediate construction, as opposed to looking back decades and even centuries and understanding how that impacted the development. And it reminds me a little bit about of Acharya's theory of norm circulation and all the different factors that can feed into the development of systems or norms or governance structures. And very much agree with your call of the need to kind of design theories that perhaps look at regions or even like smaller spaces, as opposed to squeezing the distinct and often unique experiences and trajectories into universal buckets. And I think that gets to kind of a first overarching question for me, is that you say, of course, that all states are unique, but that you have found some common threads across Africa based on regional experiences and ideas and norms. And I'm wondering if you think this is unique to Africa, or if every region might have unique constitutional experiences or trajectories that we can draw upon. And in fact, we need to be moving away from kind of universal theories and more look at, particular spaces, particular regions potentially, for how they developed and maybe what they bring to the table. Kind of looking at the intersection of international law and indigenous development, again, that kind of resonated with me at the regional level. So I wonder, if there were ways to look up and down the levels of governance to see how these broad ideas apply. And one of the things that was brought to mind for me at the regional level was the establishment of the Peace and Security Council, perhaps drawing on some international models, as well as the Panel of the Wise. And all of that's kind of built into the African peace and security structure. And so it reminded me of your remarks on kind of how African constitutionalisms draw on an array of different legal and political traditions in their construction, as well as kind of your remarks on not taking sovereignty for granted, and that sovereignty is part of the construction of African constitutionalisms, potentially in part because of the colonial experience. And so that's just, I think, all to kind of draw some of the similarities and how there might be a lot of value, again, of looking up and down the levels of the international system, as well as across regions, to show kind of the value of the theory you're putting across more widely. In terms of, how it's applied and how it's continued to develop, perhaps a more challenging question, although I think you got a little bit to this when talking about how there are still difficulties in constraining the executive. I'm wondering how you view perhaps a pattern or perhaps more instances of term limit creep across many African constitutionalisms or across African constitutions, and if that fits in with your theory somehow, and if there's any other kind of more recent political developments that you think fit in, but that are just emerging. So I will leave it there, and thank you so much again for the presentation. And so I'll hand it back over to you to to answer, because I know Massimo and I put a lot of questions on your plate across 2 different disciplines. And I'll ask the audience to please start thinking of questions. If you have one, you can raise your hand using the reaction button. You can also, if you don't want to speak, you can type your question into the chat and I'd be happy to read it out. And once we get started with the general discussion, we'll take 2 or 3 questions at a time. So thank you again. Over to Berihun.
Thanks so much for these generous comments, Massimo and Kathryn. So I took note of many questions. Some of them I think I have to think about it further, but I will simply share my views and thoughts on those questions. So in terms of that, I think Massimo, you are right, because my main aim in this book is to think at the level of generality, so that I will be able to say something. And of course, the danger with this is, the devil is in the details somehow, and then so to this extent, the idea of legal centralism, which much of legal positivism, very positivistic legal thinking about law, about constitutions. There are many theories within the legal centralism category. And there are also many theories on the legal pluralism category. And in the book, I talk about legal pluralism more generally, just to make the point that even when we talk about legal pluralism, much of the discussion in the African context is limited within the within the state. That we have colonialism is a point of departure for this legal pluralistic thinking. That we have different customs, different customary laws, different religious laws, and then we have also imported European laws. And we usually think legal pluralism through this this framework. But legal pluralism is, I think, much broader. It applies to all societies, in Europe, everywhere. So in the book, I took the narrow version of legal pluralism, how people engage with laws and constitutions on the continent. So to that extent, my account of legal pluralism, in the book, I have an extended discussion, but for my purpose, it was really thinking through these very classic ideas of legal pluralism, very classic ideas of thinking about law and constitutions. And the other related to the non-state actors. What is the role of non-state actors? What is the role of religion? So when I talk about the state, and when I talk about international law and institutions, it also includes NGOs, international NGOs, international organizations, and partly in many countries, these NGOs actually perform state functions. So they perform very they have huge role in many parts of the continent, and then they may have also their own impact, either positively or also negatively, in shaping constitutionalism or constitutional government in one or the other direction. So the idea of bringing international law, and I think this is also what Kathryn was saying, include international relations also, the role of these non-state actors. I have also those things in mind. Related to the role of religion and custom, I think it is like part of the indigenous system. In some places, especially in Muslim-dominated countries, they had already a legal system based on Islam, which means that, but then those Islamic-based legal systems has been, especially in former British colonies, has been, or also in French, has been considered as, you know, some sort of customary law in the indigenous law. So the idea of customary law, as you know, those colonial administrators see it, they didn't make that much distinction between it's just indigenous law. It could be custom, it could be religion. So, you know, and that's very important. And related to how this also applies, I will talk about religion and also courts. I mean, you also talk about like what is the role of the judiciary in this process, and how actually religion influences constitutional government. I took 3 countries. So in the first 3 chapters, I talk about, you know, issues at a very general level, but then I choose 3 countries, not as comparative as such, but as case studies to, you know, to demonstrate and to give some concrete examples. If you take Nigeria, for example, some states in northern Nigeria live according to, you know, Sharia law. And some other parts of the country live under, you know, secular law. There you would see constitution, what Ran Herschel calls it, constitutional theocracy. You see in one country, you see constitutional theocracy and constitutional democracy. And the interesting thing is how this thing is possible. So if you see the Nigerian constitution, if you focus on the written document only, you know, it doesn't say, you know, Nigeria is a very secular country. Of course, Islamic laws and customary laws could be applicable in personal and family matters, civil matters. But what we have seen for the past 2 decades, even maybe over, that some states actually are living within the dictates of Sharia, you know, for implementing Sharia law, criminal law, so on and so forth. So they try to navigate ways to make all this system work. And one of the things, I think one of the constitutional devices that enabled Nigeria to live within these 2 seemingly bifurcated but united constitutional order is syncretism. So in terms of the role of the state, I think, you know, the state has been the primary unit in the sense in my analysis, and the state is important, and then I show what we could do within those territorial states. You know, obviously, you know, regional integration is one of the ways of enhancing sovereignty, to create conditions to have, you know, a functioning constitutional government. But at the same time, we cannot simply, you know, abandon territorial status. You know, they have their own logic. They are grounded, even if so. So what we could do is to understand, you know, their logic. So somehow they are connected to the international system, international institutions, NGOs for their you know, existence, but at the same time they have also a local basis. So these traditional systems, religious systems, are also you know, in a unique way created a state that could maintain it against the odds. You know, if you see Somalia, you know, we don't have a central government in Somalia, but no one is not you know, going to Somalia to acquire, you know, to they exist. under their own, religious-based laws. So the state is important. So what I try to show in the book is the state, the kind of state we have is different. And we need to understand that to, improve both, democratic performance and constitutional government. Yeah, so I think there are many questions. Probably I have to, for the sake of time, I have to, I may have to pass it. The book is, first, it is primarily descriptive. It tells what constitutions and constitutionalism are. And only after this that, it suggests some, normative prescriptions, like how can we enhance sovereignty? How can we do constitutional reform? Or how can we mediate diverse constitutional values? So Kathryn's point, I think I totally agree with you, and it's it's really interesting to see. I'm a lawyer, but also like I build a lot on international relations and international law material, and I look forward to reading your new book. On this. I think it will help me a lot in understanding more on that front. So whether legal syncretism is unique to Africa, I think it is unique in some ways, but it is not so much unique in other ways. It is unique because, for example, colonialism happened in Africa very late. And it was facilitated by international law, by international treaty. Because it was facilitated by international treaty, colonization happened fast, and it is, effect was radical. So the role of international law as, as a basic law or as a constitutional document in restructuring that continent is somehow unique than, other places like Asia or Latin America. But in other ways, syncretism is a result of an encounter. It could be an encounter between colonialism and imperialism. And now we are living in the age of globalization. And different states have different state capacity in dealing with, this new reality. So to some extent, it could become even the feature of constitutions, not only in Africa, but also, in many parts of the world, because there is an international system. So the state-based constitutional system, and it faces the international system, and this creates unique dynamics. It's a condition. So it is a struggle within a social field. And we have all these things. The degree and the extent may be different, but I think it could, we could find it in many places. And the other is, so in terms of the African Union and regional, regional institutions and organizations, I think that's important. And I consider, one pillar of constitutionalism is actually international law. If you see democracy, I think this is also what Massimo was talking earlier. So the concept, so the idea of democracy we have, at least, in legal and political terms, democracy is a continental project. In Africa, I think, which is very unique in many ways. So countries may not amend their constitutions, even if they want to. There are some continental standards. There is, as you say, the Peace and Security Council. There is the African Court, the African, there are rules and institutions. And democracy is, it's not the domain of status only. It's a very continental project, but at the same time, it has also, of course, it is the state is the engine. So to that extent, it creates literally a constitutional, a constitutional. So the African Union or the African Union project could be considered as a constitutional project. From the OAU, the priorities may be different, but it has a very constitutional element. And related to the executive, I think you are right, because legal syncretism is contingent. It could be bad for democracy, it could be bad for constitutionalism, but it could be also good. So it is contingent upon a number of factors. And if you see the executive, I have a whole chapter on the executive. The executive actually, it looks like we have separation of powers. We have parliament, we have, president or prime minister, we have courts. But if you see the power allocation and the way the executives, engage with the different branches of government and with the bureaucracy and with, with the people at large, it is entirely different. And the kind of executive we have is, somehow, the colonial governor in a modern guise. The colonial governor has, had, all legislative, judicial, and executive powers. So they actually accepted that theory of government. And that's why we need term limits are limiting the power of executive, what the executive can do, and also, how long. So both the temporal and substantive limitation is extremely useful and important. I could go on, but I think for the sake of time, I should stop here.
Oh, thank you so much for engaging in all the questions.